So, we're just a few days out from the under 16 social media ban here in Australia, and the lawfare has finally started. A little later than I expected, but better late than never. It looks like someone with a backbone has finally woken up and chosen the legal equivalent of violence. It sucks that it's been left to a pair of teenagers, but it's nice to see some stones from the next generation. Just as a quick refresher in case you've been living under a rock, the Australian government has told 2 million kids that they are too stupid to handle the dangers of TikToks and X, so they're banning every Australian under the age of 16 from having a social media account starting on December 10 this year.
From 10 December, social media platforms will have a responsibility to remove young Australians under the age of 16 from their platforms. With the support of the regulatory guidance being published today, there is no excuse for non-compliance. We will always keep backing Australian families and keeping Australian kids safe.
What a crock of shit. There's been a media blitz in the lead up, with mainstream media outlets trotting out a number of parents who have suffered the unimaginable loss of their children to online bullying. I personally find this manipulation of a parent's grief and misplaced anger like that to be absolutely reprehensible, but I'll talk about that at another time. Why we're here today is to talk about the most delightful piece of legal rebellion that I've seen in years. Two 15-year-old teenagers, Noah Jones and Macy Nayland, backed by the glorious madmen at the Digital Freedom Project and New South Wales libertarian John Ruddock, have hauled the federal Commonwealth government into the High Court in an attempt to stop this idiotic under-16 social media ban before it turns an entire population of teenagers into digital ghosts. If you're new here, feel free to hit the like and subscribe button for more legal and political breakdowns and rants. Consider joining me for a live stream on the Overlaw'd live channel, or finding me on X, Patreon, or at the Underlord Discord. All links will be in the description. And as always, do your own research and come to your own conclusions. But stick around, we're going to look over the details of this lawsuit, and then we'll break down the writ of summons that's been filed in the High Court. Now, let's get the facts straight first, because the media is already memory holing exactly how extreme this thing is. Australia's Parliament, in a rush and fit of bipartisan enthusiasm that would make even the most ardent nanny stater blush, slammed through the Online Safety Amendment Social Media Minimum Age Act of 2024 on the 29th of November 2024, inserting a new Part 4A into the Online Safety Act of 2021 and creating the world's strictest age gate on social media. Absolutely no accounts for anyone under 16. Full stop. This isn't a let's encourage parents to parent suggestion, it's a blanket corporate penalty regime that forces platforms, X, TikTok, Instagram, YouTube, Reddit, the lot, although conspicuously and conveniently not Blue Sky for some reason, to stop Australian kids under 16 from holding accounts. Not just viewing, but holding accounts. You can still lurk logged out like some sort of digital pleb, but you can't post, DM, organise or properly participate in any way in any sort of modern political discourse that actually happens. The E-Safety Commissioner gets to fine companies into the stratosphere if they fail to take reasonable steps to enforce it, and while the exact age verification methods are left to industry, everything from biometric checks to ID uploads is on the table, and even this close to the date, details are still sketchy about what will meet government approval. So yes, there is possibly still a good chance that your 15-year-old daughter will have to upload her passport in order to be able to tell Anthony Albanese that he's a wombat. This is supposedly what they call progress. The law explicitly targets age-restricted social media platforms, essentially any service whose sole or primary purpose is letting users post material, link up, or interact, which sweeps up, as I said, TikTok, X, Instagram, Facebook, Snapchat, Reddit, YouTube, Kick, Twitch, and Threads. But again, not Blue Sky for some reason, even though it's a complete clone of X. Go figure. The provisions commence on 10 December 2025, barely a year after it was passed, in what the government has framed as an urgent shield against addictive algorithms, harmful content, cyberbullying, and supposedly the general cesspit the social media has become for vulnerable minds. But on 27 November 2025, with the clock ticking down to the December deadline, the Digital Freedom Project Incorporated, an association founded to defend young Australians' rights to participate in political discourse online, and energetically backed by New South Wales Libertarian MP John Ruddock, filed a writ in the High Court alongside two remarkably articulate 15-year-olds. The plaintiffs' arguments are brutally simple and, in my opinion, completely correct. They argue that the blanket ban is constitutionally invalid because it directly burdens the implied freedom of political communication, that glorious judge-made safeguard derived from Section 7 and Section 24 of the Constitution, which ensures that the system of representative government actually functions. Look, I know that the implied right to freedom of political communication is not much, but it's all we've got at the moment. Their case is elegantly simple and devastating. They allege that hundreds of thousands of 13 to 15-year-olds already use account-based features to discuss politics, criticize government policy, organize campaigns, and occasionally tell politicians to get fucked in the comments, allegedly. They also use it to follow journalists and generally learn how democracy works in the digital age. The ban doesn't just inconvenience them, it silences an entire generation from the primary public square of the 21st century, right when they're getting to form political identity. I wonder why the government would be opposed to kids forming opposing political views to those based on the curriculum decided by the government.
Unfortunately, some members of the media
use their platforms
to push their own personal bias.
To push their own personal bias and agenda to control exactly what people think. This is extremely dangerous to our democracy.
They say that logged out browsing is no substitute. It's like being allowed to read the newspaper but forbidden from writing letters to the editor or attending a town hall. They rightfully point out that this interactive political speech is not trivial youth indulgence. It is essential civic education for future voters, a vital feedback loop for politicians who need to hear unfiltered youth concerns. Not just youth. I mean, does anyone else get a bit of a kick when you manage to ratio a politician when you catch them lying? But they say that it is crucially part of the constitutional machinery of representative government itself. Also, advocates for vulnerable cohorts that are saying that LGBT kids, rural teens, neurodivergent children, and migrant youth all rely heavily on these platforms for community and expression without fear of local reprisal. The plaintiffs accept that protecting children from genuine online harm is a legitimate goal. What they reject, however, is that this sledgehammer is the appropriate tool to do so. And look, take it from someone who is subtle as a sledgehammer on most occasions, I think they're right. This requires subtlety. They run the full Lange-McCloy analysis, which is a legal test as to the proportionality of a law and if the restrictions that it imposes are justified. They argue that the law is not suitably tailored, given that it bans everything instead of targeting addictive features or harmful content, that there are obvious, less restrictive alternatives that exist, such as parental consent for 14 to 15-year-olds, mandatory duty of care and design rules for platforms, privacy-preserving age assurance technology, digital literacy programs, etc. And finally, they argue that the balance is grossly inadequate. An entire age cohort is exiled from their primary public square with zero incentive from platforms to actually fix the problems that the law claims to solve. They also throw in claims of breaching the Convention on the Rights of the Child and the ICCPR for good measure, noting that the ban forces teens like Macy Nayland, who turned 16 shortly after the commencement, to surrender her biometric data or ID data and thus her anonymity simply to keep speaking up.
What?
I mean, I personally could not agree more. I mean, what was the Ben Franklin quote about giving up liberty for safety and deserving neither? I've probably completely butchered that. If some Americans can correct me in the comments, that would be awesome. The teens themselves have been scathing. As Noah Jones said, and I'm quoting here because it's perfect, "We're disappointed by a lazy government that blanket bans under 16s rather than investing in programs to help kids be safe on social media. They should protect kids with safeguards, not silence." Macy Nayland warned that it will drive children to fake profiles and VPNs. And she's completely right. I mean, you're concerned about the damage that social media is doing to your kids? Imagine what happens when they eventually find their way onto the dark web to get around this. That's where the real danger is. Macy says, and again I quote because it's gold, "If you personally think that kids shouldn't be on social media, stay off of it yourself, but don't impose it on me and my peers. Driving us to use fake profiles and VPNs is bad safety policy." John Ruddock has called it a direct assault on young people's rights that indirectly trespasses on everybody's privacy through inevitable ID checks. And that's what I've been saying. This was never about protecting kids. This was about forcing adults to provide their identification in order to link to their accounts to be out online. We already know that shortly they're going to be forcing us just to use our ID in order to search Google. There is not going to be any anonymity online.
All right, you ready?
Freeze! We're the internet police. You guys are going away for a long time.
Say some kid falls off playground equipment at a park. Do we ban kids from playing in the park, or do we put guardrails up and act like adults and watch our kids better when they play? Let's apply the same logic to adults. There's a few idiots out there that decide to drive drunk. Absolutely ridiculous. But do we attach facial recognition and breathalyzers to every car on the road? Actually, you know what? That's a bad example because I know there's some nutters out there that'll be over the moon about that. I mean, the e-safety commissioner started spouting off about how smart cars and electronic vehicles now fall under her jurisdiction. But I'll save that for another video. The Albanese government's response has been characteristically dismissive. Communications Minister Annika Wells declared that they will not be intimidated by big tech or legal threats. Translation? Sit down, shut up, we know better than the actual children and the Constitution. Classic Labour in my personal opinion. Just going to break in here after the fact because I was rereading what Annika Wells actually said. I find it hilarious that she's sitting there talking about legal threats and challenges from people with ulterior motives when you've got the bloody e-safety commissioner here, in my opinion, running her own personal vendetta against everything to do with Elon. Firstly, social media, now she's going after smart cars. You can't tell me that's not about X and Tesla. Now, unfortunately, the legal academics are lining up to say that the kids will probably lose the case. Associate Professor Luke Beck, when he was writing for The Conversation, described the burden on political communication as slight at best, arguing that very few teens are genuinely using social media for serious political discourse, and compared the ban to age limits on alcohol or entering pubs, none of which have ever been struck down. With all due respect, Professor, there's a fucking difference between stopping a 15-year-old from getting pissed and, say, stopping them from telling the government to get fucked for stepping on their rights. One is child protection, the other is authoritarian cosplay. Former Chief Justice Robert French earlier advised in a similar South Australian proposal that the implied freedom is not engaged when the law is content neutral and protective. Again, Your Honour, I respectfully disagree. I don't believe that this is content neutral. I believe that it is a way of silencing discourse that the government does not like, and as for whether or not it is protective, I believe that that is up to the parents, not the government. Most commentators unfortunately expect the challenge to fail, and urgent injunctions are vanishingly rare. But I mean, here's the bit that gets my blood boiling. The government admits that the harms are addictive design features and harmful content, and why not legislate a duty of care from the platforms? Why not instituting privacy-preserving age assurance instead of demanding passports? Why not parental consent for 14 to 15-year-olds? The answer is because that would actually require work and some balls. It's easier to ban 2 million kids and call yourself a hero. And let's be crystal clear, I'm not saying social media is harmless. It can be an absolute sewer at times. But the solution is to fix the sewer, not dynamite the entire city and tell the residents that they should be grateful. These kids are showing more maturity than the entire federal parliament. The Digital Freedom Project is crowdfunding the case. The link will be in the description if you want to chip in for actual freedom instead of some performative safety theatre. Platforms are already moving. Snapchat has already notified hundreds of thousands of Australian users about their accounts, Meta's preparing to lock down, and YouTube has previously flagged its own potential court challenge.
For now, most of the popular apps on the banned list have begun informing users under 16 that their accounts will be shut down in the week ahead.
In the meantime, the kids are already finding alternatives, flocking to Yope and Lemonade for alternatives.
We watched what American kids did when TikTok went blank. They went to Red Note, they went to Lemonade, which is an Instagram clone.
With the under 16 social media ban to begin in 10 days, some students have shifted to smaller providers not on the government's banned list. Yope, a photo sharing app listed as lifestyle, rocketing up the App Store charts.
Some of that's going to happen inevitably, but that's what teenagers do.
No shit, Sherlock. The Australian government really did not think this through. And they're going to continue to play a game of whack-a-mole for however long with these kids. Whatever the outcome, 2 15-year-olds have forced the nation to confront whether protecting children
Won't somebody please think of the children?
can ever justify muting an entire generation from the modern public square. As of 1st of December, the matter is live in the High Court, with the plaintiffs urgently seeking an interlocutory injunction to stop the enforcement until there's a full hearing. The court's next sittings are in the first 2 weeks of December, so a lightning-fast decision is possible. If the injunction's refused, the ban hits on December 10, and the full case rumbles into 2026. If the injunction's granted, we get to watch the government squirm over Christmas, which would be the best present ever. So let's have a look at the writ itself. But before we get there, hit that like button if you think 15-year-olds should be allowed to call politicians wombats, subscribe for more unapologetic truth, and comment "fuck the nanny state" if you agree. Okay, so let's have a look at the document. High Court of Australia, notice of filing. This is the fairly straightforward, automatically generated covering sheet when you file something. In the High Court of Australia and the Sydney Registry, between the Digital Freedom Project Incorporated, Noah Jones by his litigation guardian, and Macy Nayland by her litigation guardian, versus the Commonwealth of Australia, the E-Safety Commissioner, and the Minister for Communications and Sport. I'll be honest, it annoys me that Annika Wells has 2 portfolios. I kind of feel like communications for the entire country should probably be something that is handled independent of, say, another one, but that's my own personal opinion. King Charles III, by the grace of God, King of Australia and his other realms and territories, head of the Commonwealth, to the defendants, the Commonwealth of Australia, the E-Safety Commissioner, and the Minister for Communications and Sport, take notice that this proceeding is brought against you by the plaintiff for the claims set out in this writ. If you intend to defend the proceedings, you must file a notice of appearance. If you are willing to submit to any order the court may make, save as to costs, you may submit a submitting appearance. They have 14 days to respond to this, which was lodged the 27th. So they have until the 11th to file a response to this. Statement of claim. The parties. The first plaintiff, the Digital Freedom Project Incorporated, hereunder known as DFP, is an incorporated association established in New South Wales under the Associations and Corporations Act, whose objects include promoting and protecting the participation of young Australians in public affairs and political communication, particularly online. DFP operates a program through its website promoting freedom of speech and communication, including on political and government matters. DFP has members who are under the age of 16 and who, prior to the commencement of the measures pled below, used accounts-based features of major social media platforms to receive, impart, and organise communications on governmental and political matters, including with the DFP's own programs. See, this is interesting because I'm unsure if this is them attempting to say, we specifically know that these kids are using social media platforms for political truth because we've been engaging with them on those platforms, but I'm curious as to whether or not that started before or after the legislation passed last year. If it's only really been that they've been doing this in the last 12 months, then it may be seen to have been tangentially related, so yeah. Anyway, the second plaintiff is Noah Jones, a minor aged 15 who sues via his litigation guardian. Noah is a secondary student residing in metropolitan New South Wales. He is engaged in learning about current affairs, politics and public issues, and participates in civic discussion primarily through online media and social platforms and in-person events. These proceedings are brought on his behalf to challenge the lawfulness and the constitutional validity of restrictions which prevent or substantially burden his ability to access, receive, or participate in political communication online. The third plaintiff is Macy Nayland, a minor aged 15 who sues by her litigation guardian. Macy is a secondary school student residing in regional New South Wales. She'll turn 16 just before the Act comes into effect, but is affected by the Act forcing her to surrender her privacy and anonymity by submitting personal information to continue using social media. Macy is engaged in political and civic matters, uses online platforms to follow journalists, discuss policy, and participate in campaigns. She says that anonymity is essential for young people, especially girls in small communities, to express opinions safely and participate freely in public discourse. She believes that the law unjustly treats all young users as risks rather than responsible participants, and the less intrusive measures such as parental oversight, education, and privacy protective tools could achieve safety without undermining privacy or political communication rights. It goes through the defendants, the Commonwealth of Australia, the E-Safety Commissioner, and the Minister for Communications. There is a significant... Okay, so the impugned scheme. There is a significant community of Australian citizens aged between 13 and 15 years of age who exercise their freedom to engage in communication on political and governmental matters by registering accounts on social media services that have the purpose of, or have a purpose of, facilitating such communication between those citizens, between them and members of the Commonwealth and state parliaments, of public officials, political parties, media organisations, and Australian citizens entitled to vote in federal and state elections. The use of social media by these citizens enables them to share by posting and messaging in an interactive manner information about and to discuss political issues and governmental policies, inform themselves about political matters and what their political representatives are doing, to criticise and comment on or advocate for or against government policies and their political representatives, formulate and advocate for government policies to members of parliament, political parties, citizens entitled to vote, and to each other, and to mobilise young people to engage in political discussion and activity. The exercise of this freedom of political communication by these citizens is necessary for their education in political and governmental matters and in preparation for the exercise of voting rights in choosing political representatives upon them being entitled to vote. The exercise of this freedom of political communication by these citizens is necessary for the education of their political representatives about the opinions, concerns and preferences in relation to political and government matters of young Australians, and to enable those representatives to properly and effectively formulate government policies for the benefit of young people presently and in the long term. The exercise of this freedom of political communication by these citizens is necessary for the integrity and efficacy of the system of representative and responsible government mandated by the Constitution. Some of those citizens are members of DFP, members of LGBTQIQA+ communities, children in rural and regional communities, disabled children, neurodivergent children, migrant children, and users of anonymous online mental health services for children and adolescents. So what are they really saying there? That there's a huge community of 13 to 15-year-olds who already use social media to do actual political stuff, like messaging MPs and organising and criticising the government, all that sort of stuff. It's not just kids scrolling. This is how Gen Alpha participates in democracy. Blocking them from the platform is like banning under 16s from polling booths or youth rallies in earlier generations. The Amendment Act was passed by the Commonwealth on 29 November 2024. The amendment amended the Online Safety Act 2021 by inserting a new Part 4A into the Principal Act to establish a legal minimum age of 16 for all account-based access to social media services, referred to as age-restricted social media platforms. The minimum age provisions are due to commence on December 10, 2025. 2025. Under the scheme of the minimum age provisions, an age-restricted social media platform is defined by Section 63C of the Principal Act as an electronic service, the sole or significant purpose of which is to enable online social interaction between end users, including by allowing users to link with or interact with other users and to post material. By reason of Section 63D, providers of such services must take reasonable steps to prevent persons under 16 years of age from creating or holding accounts. Substantial civil penalties may be imposed on service providers for non-compliance with Section 63D. 30,000 penalty units. 30,000 penalty units, which at $330 per unit is $9.9 million per instance. The Online Safety Age-Restricted Social Media Platforms Rules 2025, promulgated by the third defendant in July of 2025, define and exclude specified classes of services, but do not exclude social media platforms used for communicating on political or government matters, and when the scheme commences on 10 December 2025, it will apply to then existing and new social media accounts operated by persons under 16 years of age who wish to exercise their freedom of communication on political and government matters by use of social media platforms falling within the meaning of age-restricted social media platforms. On their proper construction and intended operation, the minimum age provisions will prevent persons under the age of 16 from using account-based social interaction to engage in communication by, to, and between them of political and government matters on all social media services and platforms that are principal fora for such communication by 13 to 15-year-olds in Australia. Logged out viewing does not provide a meaningful substitute for the interactive functions which are integral to and necessary for contemporary modes of free political communication by persons aged between 13 and 15 years of age, and for the maintenance of integrity and the efficacy of the system of representative and responsible government by the Constitution. So basically what they're saying is from December 10, every major platform becomes an age-restricted social media platform. The platforms have to take reasonable steps to stop under 16s from having an account, and just looking without logging in doesn't count. You can't comment, DM, post, organise or do anything interactive. The plaintiffs say that this basically kills political participation. The second plaintiff regularly accesses and uses online media and social networking platforms including TikTok, X, YouTube and Instagram for the purpose of receiving information, news and commentary on matters of public and political interest. And basically after this would be required to effectively rely on mainstream media for news and political information. That's a terrifying thought. The second plaintiff uses those platforms to engage in communication discussion concerning political, governmental and social issues with family members, peers, teachers, adult relatives and members of parliament and local councillors. They engage with public and political issues through social media, forming a substantial part of the plaintiff's civic education, personal development and participation in democratic life. The second plaintiff will be adversely affected by the proposed or enacted measure described herein, the under 16 social media ban, which prohibits or substantially restricts persons under the age of 16 from creating or maintaining accounts on or otherwise accessing social media platforms, and will be prevented from accessing and participating in online communication and discussion due to the ban, thereby his freedom to receive and impart political communication protected by the implied freedom of political communication under the Constitution of the Commonwealth of Australia. The third plaintiff will be required to verify her age and identity to continue to use her social media accounts, even though she will soon turn 16 years of age. She will have her privacy compromised if it is required to upload personal identification like a passport or driver's license. And at 16, she may not have a driver's license. So, photo and birth certificate, which I don't want any corporation having. She will lose her online anonymity, making her identifiable to social media companies and potentially others. She will feel less able to share opinions or engage in political and social discussions online. Chilling effect, anyone? She has concerns about the risk of her personal data being stored and shared and misused. She'll be susceptible to greater exposure to local judgment or harassment in her small regional community if her identity becomes known. Now, someone's going to make the argument that she's plastered her face all across the news and therefore her identity is already known. That's different to her identity being attached to her opinion online. Like, it's very clear that she is the one bringing this. She's a plaintiff in this case. She's obviously one of the faces of it, but she's not actually espousing what her political opinion is. She'll be susceptible to unfair treatment despite using social media responsibly for education and civic engagement. She'll find it harder to participate safely and freely in public debate, and will be forced to choose between keeping her privacy and maintaining access to online platforms. DFP will be adversely affected in that its own members under the age of 16 and other members of the community under age 16 will be prevented from using DFP's programs to engage in communication on political and governmental issues. I mean, so what? What they're basically saying there is that Noah's going to be locked out of political discussion the day that the law starts. Macy's going to have to upload her passport or driver's license even though she'll be 16 soon, and she will lose what anonymity she has that she says is essential for girls in small towns to speak freely. Okay, the burden on political communication. In their terms, operation and effect, the minimum age provisions will interfere with and adversely affect the exercise of freedom of communication on government and political matters in Australia by all interested parties aged between 13 and 15 years of age. For these reasons, the minimum age provisions burden the freedom of communication on political and government matters embedded in the Constitution. Now, to be clear, Australia doesn't have a Bill of Rights, but the High Court found that there is an implied freedom of political communication in the Constitution. First in the Lange case in 97, then it was revisited in Coleman in 2004, and then McCloy in 2015. The plaintiffs basically are saying that the age ban burdens the freedom because it stops an entire age group from speaking and engaging about politics on main forums where the politics basically happen now. The asserted purpose of the minimum age provisions is the protection of children from online harms, the purpose of which the plaintiffs accept is compatible with the system of representative and responsible government. The online harms identified as the harms to which the minimum age provisions are targeted are harmful content available to account holders on social media platforms with a significant purpose of social media interaction with end users and the application by the service provider to these social media platforms of design features and functions which have the effect on vulnerable young people of encouraging them to expend increasing time online and making them addicted to social media use. They then go on to say, however, that the minimum age provisions are not reasonably appropriate and adapted to achieve that purpose because, while there is a superficial rational connection that the minimum age provisions operate on the accessibility for 13 to 15-year-olds on social media platforms, they are not rationally targeted at the specific features of social media platforms which generate the harms from which they are intended to protect people, and they will have the effect of sacrificing a considerable sphere of freedom of expression and engagement for 13 to 15-year-olds in social media interactions, including communications on personal and government matters and the benefits to those people of such interaction, without any discrimination and not rationally connected to the identified harms. There are obvious and compelling, reasonably practicable, less restrictive alternatives to a blanket ban on social media platform accounts, including but not limited to parental consent, legislating an enforceable duty of care and design obligations on providers, limiting the definition of age-restricted social media sites to include those that are relevant to the platforms that operate one or more of the harmful designs, which actually cause the harm, strengthening reporting, takedown standards, and digital literacy programs in schools. The breadth and severity of the burden categorically excluding an entire age cohort from access to the primary forum for online social interaction, including political communication, is an oppressive, overreaching, and an inappropriate means to achieve the object of child protection and fails to impose any incentive for social media platform providers to ameliorate the actual harmful features of their services delivered to young Australians. Further, the minimum age provisions are incompatible with and clog on the enjoyment by young Australians of the right to freedom of opinion and expression in Article 19 of the International Covenant on Civil and Political Rights and Articles 12 and 13 of the Convention on the Rights of the Child, including the right to have their opinions expressed in decision-making processes that relate to their lives. The right of a child to engage and participate in cultural and artistic life in Article 31 of the CRC, and the right to access information and material from a diversity of sources in Article 17 of the CRC. The minimum age provisions are not reasonable and proportionate to achieving legitimate objectives in the way that justifies the blanket restriction on those rights. Accordingly, the minimum age provisions infringe on the implied freedom of communication on governmental and political matters and are invalid to the extent of that infringement. Okay, so that was a whole heap of legal jargon. Let's break it down a little bit more into a layman's terms, shall we? The plaintiffs actually accept that protecting kids from the online harm is a legitimate goal, so they can't just win by saying, well, free speech is supposed to always win. They have to show that the law fails the three-part proportionality test that the High Court uses, which is the Lange, McCloy, Club, Liberty Works test that's developed over the years. So firstly, they had to look at suitability. Is there a rational connection between the ban and the goal? They say no because the ban doesn't target the actual harmful features, infinite scrolling, algorithmic dopamine hits, beauty filters, all that sort of stuff. It just kicks kids off entirely, even when they're using the platform responsibly for politics. Then they had to look at whether or not there was a necessity for the law. Is there an obvious, less restrictive way to achieve the same goal? They've listed 5 different alternatives: parental consent, forcing platforms to have a legal duty of care, only banning platforms that have the really addictive features, better reporting and takedown rules. I'm not sure how I feel about that one, if I'm honest, and having actual digital literacy education education in schools. They say any of these will protect kids while still letting them speak politically. I have an issue with the actual digital literacy education in schools as well, because I feel like they're actually going backwards in that. Then they have to argue over whether or not it's adequate in the balance of all things. This is where they go the hardest. Completely banning an entire age group from the main arena of modern political discourse is grossly disproportionate. It treats every 15-year-old climate or political activist, queer kid in a conservative town, or young person organising a rally as the same as someone doom scrolling at 3 a.m. They say that the law is oppressive and overreaching and removes any incentive for platforms to actually fix their harmful features because the kids are just gone. They throw in that the ban also breaches children's rights under the UN Convention on the Rights of the Child, Articles 12, 13, 17 and 31, the right to be heard, freedom of expression, access to information, cultural participation. Australia's ratified all of these treaties, and while they don't directly override statute, the High Court sometimes uses them to help interpret the Constitution or to lean towards a rights-friendly reading. All right. Back to a little bit more legalese. Alternatively, if and to the extent that any part of the scheme might otherwise be valid, the minimum age provision should be read down, so chopped up, severed, read down to their basic level, pursuant to Section 15A of the Act's Interpretation Act, so that they do not apply to prevent or hinder communications reasonably characterised as political communication by persons under the age of 16, or to require providers to take steps that would have that effect. I mean, to be honest, I feel like that would sort of, if they did read it down in such a manner, it would mean that the only exemption would be for 14 and 15-year-olds to have accounts that are only allowed to discuss political stuff. That's not very practical in my opinion. The rules are invalid to the same extent if, properly construed, they extend to the operation of the minimum age provisions to communications reasonably characterised as political communication, or they are otherwise beyond power by reason of the implied freedom. Alright, so they then go on about the jurisdiction. This is a matter arising under the Constitution involving its interpretation. Constitution Section 76(1), conferred by the Judiciary Act 1903, and Section 75(5), as against the second and third defendants as officers of the Commonwealth. So what are they after? Here's the relief. A declaration that the minimum age provisions are invalid as they burden the implied freedom of communication on government and political matters. Injunctions restraining the second and third defendants, whether by themselves, their officers or agents, from taking steps to enforce the minimum age provisions to the extent that such steps would prevent or hinder political communication by or to persons under the age of 16. Alternatively, an order that the minimum age provisions be read down or severed so as to not apply to political communications pled above. Costs, and my favourite phrasing of all time, such further or other orders as the court deems appropriate. I do love that. So what does it boil down to what they're after? They're after a declaration that the age restriction is invalid, either wholly or in part. They're also after an injunction stopping the Safety Commissioner, Julian Grant, from enforcing it against political speech. Alternatively, they're after an order that would exclude political communication, and they're after their own costs. But what is the actual bottom line of all this? Well, they have to convince the High Court that kicking 13 to 15-year-olds off social media is a disproportionate response to online harms when obviously less drastic options exist, and that the burden on political communication is severe and unjustified. This is probably the most important free speech case in Australia since the 1990s, because it asks whether or not the Constitution protects the way politics actually happens in 2025, not 1925. Effectively, the High Court either has to accept that the implied freedom of political communication exists, or they have to throw out the legal gymnastics that they did to put it in place in the first place. I mean, they could just say, oh, people under the age of 16 don't have freedom of political communication, but that's going to open up a whole nother can of worms. If the kids win, the government will almost certainly have to go back to the drawing board and write a narrower, smarter law. If they lose, Australia will have the strictest under 16 social media ban on the planet. But all right, folks, we'll wait and see how this one pans out. As always, stay healthy, wealthy, and wise, and I'll catch you all on the next one. Cheers, peeps.